officer engaged in conduct that violated the United States or the Florida Constitution, the fact that they took an oath to maybe uphold the law would be irrelevant to my decision that they did or didn't violate the law. I would make that objectively based on the facts presented at the time. I would have to make that judgment.
Right. I would.
So in other words, judges rule on issues of law, juries rule on issues of fact, and what he's trying to do is to keep everything moving in the proper direction to get the case going forward. Again, that's some more mindless ramblings from me, again, based upon the passion of my ignorance at the time.
Understand that within the function of the trial. However, if prior to getting to the trial, we discover that, well, now you're operating outside the Constitution to move the case forward.
That's a legal argument that you would have to make representing yourself is to raise the issue in an appropriate motion and allege specific conduct or activity on a factual basis that would then give you a legal argument.
Okay, let's pick this back up from where we just left about him making the factual basis statement. So I'm going to back it up, play it, and we're going to keep on moving forward.
Representing yourself is to raise the issue in an appropriate motion and allege specific conduct or activity on a factual basis that would then give you a legal argument that your rights were violated, that the detention was unlawful, and because of that, based on precedent in the Supreme Court of the United States, the remedy is to suppress all the evidence and exclude it from consideration.
Okay. And that goes back to my raising the issue of the suppression motion, which is we're going to get to, but we're not going to get to the actual suppression motion because we're going to have a dismissal prior to that. But again, you see him going to say the issue may not be all the other stuff that I'm raising necessarily, but was the stop proper? So that's where the factual basis, what are the facts that led to the stop, which in turn led to the charges being filed. Getting rid of the stop will get rid of the charges being filed, or the filed charges. Not the charge, they've already been filed, but getting rid of the stop essentially negates the charges in most instances. Again, not legal advice, just basing it upon my experiences.
I would do that, consider that, if you raise it in proper form or fashion. Whether I would grant it or not, I don't know, because I haven't seen the substance of what you would allege.
Okay.
All right, so for number 8, at this point, I don't believe that's necessarily relevant information to the proceeding, and I'm gonna, it's not probative from my perspective, and so I'm gonna deny the demand for dismissal.
Am I not going to be allowed to have a copy of their oath so that I can provide that in the event we go to trial? I would like to show the jury that they took the oath.
You're not gonna have a jury trial.
Well, I want a trial by jury.
You're not going to have one. You're not entitled to a trial by jury.
That would become pretty interesting.
Now, pay very close attention as he takes us down this historic road. This will be a little lesson in civics and some fundamentals of common law, particularly as it relates to the state of Florida.
It is going to be interesting because you're not entitled.
Why would I not be entitled?
It's a second-degree misdemeanor. And it's not a trial, it's not recognized as a trial by jury of common law. You can investigate that all you want, and if you have another issue, you can file a demand or do whatever you want. And again, I'll put it on the record, the reasons for my ruling.
Okay.
But you've been charged with that, and if you're convicted, I'm not going to impose a period of incarceration or probation.
Right, and that actually is on the record. I know it has to be
filed as well.
Okay.
I'm going to do it, yeah.
Now, what's interesting with that is not a jury trial, but a trial by jury. And I know I'm kind of anal when it comes to words because they do mean substantially different things. And if we roll back to the Rule 73 issue, which I didn't bring up here. So
I don't know, Rule 73, is that a federal?
Because I'm not consenting, yes, I'm not consenting to the issue as it is, and I've already filed.
Not consenting to what issue?
To the engagement, or I'm not consenting to the proceeding.
Again, I'm going to just come out and say, in thinking about it today, I'm like, what in the hell am I talking about? And if somebody knows something about this, they could definitely put it in the comment section, what have you, and we can address it in a subsequent video. But I don't want to start traveling back down that road for people who might be in these situations about if you don't consent to it and you send the citation forward with the do not consent and writing letters on it. All that stuff, as you see, hasn't kept them from moving forward in this proceeding, and I believe I might have did it in a couple of other proceedings, and they just kept on moving forward. It didn't matter. I'm not even sure I've been raised them after this right here. I just began to focus on the issue that led to the alleged stops. And we'll go back and look at a little bit of stuff a little bit later on as well.
And that's something the challenge to the statute.
You
Okay.
preserve whatever you think your rights are.
Okay. So I just wanted to put that into the
I'm
record.
going to go forward based on my understanding.
Right.
And I'm giving you every opportunity to preserve your rights that you believe you have in a way that there's absolutely no confusion as to my rulings, and you're not denied the right to preserve your issues.
Yes, sir.
If you decide at the end of the day, if the result is not what you anticipated, that you have every right to appeal.
That piece, that portion he gave us right there, is a jewel and a gem. And what jewel, gem, they're about the same. But anyway, he's essentially telling me, hey, look, I'm giving you this. So if you come back on appeal, the appellate court will see enough of the transcript to say, hey, listen, he's had every opportunity to preserve these rights. Is there a legal basis to what he's saying?